Item number 1, CONTC 6006 of 2022.
Let's see if in this case, the order dated 27/7/2023 has been complied with.
Has
By
been
the-
complied.
yes.
We have also filed a compliance affidavit, but it has not come on record. My lord, I've got the hard copy.
Yes. Your order. No. Correct. What was the order?
Let's see, this order was 27/7/2023.
27.
7/2023.
Lords, may I have page 9 of the application. Page 9. Okay.
While disposing of the writ.
Item 1, sir.
May I please, Lordship? Lordship, in fact, this the two matters, Lordship, and the issue involves, Lordship, because I have
Who's for the other side?
State Lordship and my.
My lord, I am for opposite party number 8.
8.
My lord, the conducting counsel was out of station due to treatment, my lord. And
What,
for which he is not present today.
it has been assigned to this bench?
In my also judicial also my.
Very
Lordship.
broken bench.
Lordship.
So I do not want any adjournments on the day. Now she is facing problems. This
You
is
know, on the health issue, Lordship.
arguing counsel has gone for a treatment. So
Lord,
when
today
you
I am
expect,
filing the written note of submission, my lord, on behalf of opposite party number
so
8.
you do not want to make any oral submission.
No, my lord, if
No, we have to be very clear in this regard. If you say that I do not want to make any oral submission, I am giving a written submission, fair enough. Then we'll hear him. It's up to you. You have to take a decision. We'll record the order.
yes, my lord.
What
Yes.
do you want?
Yes. Submit my written statement.
Your senior will not argue orally. Tell me straight away
Yes, my lord.
what?
Um,
Will argue.
nah.
Why are you prompting
I
her?
will,
Lordship.
I will file the written submission on behalf of opposite party number 8, my lord. Taken on record, my lord.
So you do not want to make an oral submission?
No, my lord.
No. I'm recording that.
Yes.
The opposite party number 6 appears. What's your good name?
Lord, senior counsel's number, जो name may be written.
Madam, if he is out of station,
No, madam. I have a strong reservations for that. If he appears, his name would be recorded. If he does not, then will not record.
Then,
That will be improper. That will be injustice.
humble prayer, my lord, kindly adjourn this matter to any other date.
I was inviting that you have to take a decision and confirm that what you want to do.
Yes.
So tell me when he will be available so that we can all of them.
He will return on 26th, my lord.
26 he will
Yes.
return.
Yes.
So can we fix this matter in the first week of September or a
Yes,
second
yes,
week of September?
First week of September.
September. Which date would be convenient to all of you?
Any date, my lord.
Because first week I think the Friday is a holiday.
Any day.
No third. If next 12.
but no third.
Because the break bench Lordship, because in regular bench Lordship is inconvenient, perhaps Lordship will make sense.
You enjoying an interim order, I think.
No, in fact, Lordship, I am the sufferer Lordship. In fact, Lordship, I am suffering. No, because this is very small
Okay,
consideration. Lordship.
Give a date. That is a Friday. 12. It's 12. It's, the the adjournment is sought on behalf of the opposite party number 6.
8.
Yes. Give all the memos. Give all the. Yes.
Item 1.
Your lordship, with your
Matter, my lord, Your Lordship, on 24/7/2023, my lord, inviting tender, my lord, for installation of radiology equipment, my lord, by the Orissa State Medical Board Corporation, my lord. Annexure 1. Their petitioner, along with other, my lord, they participate in the bid. And 28/8/2023, my last date submission of bid.
Could not get it.
My lord, the one, by Annexure 1, my lord,
Mhm.
one tender was floated by the medical board, my lord, office partner 2 and 3, and present petitioner
For radiology
my lord,
equipment.
yes, my lord.
Yes. Then
The petitioner participated, and by the Annexure 2, he was selected one of the Annexure 2 and 3, my lord. Page,
no annexure 2. What?
Annexure 2 and
Read petition.
read petition, my lord.
Yes. What?
That is my selection list.
Allenger's
Well,
Medical Private Limited.
Yes, my lord. I am MS Vision Medical Equipment Private Limited.
Mrs. Vision.
Yes, my lord.
Vision Medicaid Equipments Private Limited.
My lord. In that letter, my lord, in the bottom, the price bid shall be opened online on dated 30/11/2024,
Correct.
12:30 p.m.
Correct.
But they have not opened, my lord.
3 also.
Yes. Then.
Annexure 3 also same 2 item. Annexure 2 and 3 same date, my lord.
Yes. Then.
Then, my lord, they issue one show cause notice, my lord. Had Annexure 4.
you have concealed certain facts.
Yes, but I have filed my show cause, my lord. But thereafter, I filed my representation to open the price bid, my lord.
You
But
have been
that,
debarred for 2 years.
yes, that is, my lord, that is DGSM, but that is, there is no clause. I have filed my show cause because after filing the tender paper, my lord, that show cause note, that Deva letter was issued, my lord.
Yes.
And that effect, I filed already my show cause on 18/7. Thereafter, my lord, due to non-opening of the price bid, I approached this honorable court, and your lordship order dated 18/7/2025.
This honorable court's order.
Your lordship order on 18/7/2025.
Yes.
My prayer only to open the price bid. Therefore, your lordship, in order to expedite the matter, direct the petitioner to serve notice both by postal and already serve on next day serve.
Yes. Then.
The fee date was fixed 25, my lord.
Yes.
But after receiving on the 22, my lord, before appearing before the court, they reject the
Focus reply.
no. They reject that bid, my lord, earlier bid.
Annexure 2 and 3.
Annexure 2
2 3 disqualify.
by disqualify me.
Annexure 2 what?
Annexure 2
Selection list.
that is in my
Where is that?
well, that is I have filed in IM.
Okay. Annexure 2 the read also.
I am confused. That is annexure in my IAP 12451.
Where is that?
That is page 23, my lord.
1, 2, 4, 5,
Page 20 and 23, my lord. This is the notification dated 6384 dated 22/7/25. Name of qualified bidders M.S. Ravindra Surgical Limited. A reason of rejection, that is last, my lord.
22.
Page 22. And since the tender result is single responsibility, the committee
where are you? From where you are referring?
From
IA in my IA, my lord.
Which IA?
12451 up to 25.
Which page?
My lord,
Internal
internal page 20,
20.
my lord, of my IA.
That is not incorporated in your petition.
Because there is no option, my lord. The date was fixed, your lordship, on 25. They 22, they after receive notice.
Prayed for amendment. Subsequent
Because now they issue fresh bid, my lord. Retender it.
So he has filed it.
Yes, he cancel and retender, my lord.
Retender has been.
Yes,
What is
annexure page 20, page 25, my lord,
20?
5 of my IA.
Yes. They have not awarded a contract to anybody.
No,
Good. What is the wrong?
but wrong, my lord. During pendency, without
Because two persons were selected,
yes,
you are disqualified.
no, no,
So,
no,
Single bidder.
single
no,
bidder.
no. They two, including present person, they selected 2 person, my lord. Without
Can
opening
you
the,
challenge the order of debarment?
though there is no only no clause, only the show cause. I reply to the show cause. That of the set of
Till date, they have not.
no,
been
that is the point.
participate in this.
But they have to retender it, my lord.
Correct. They
They are not allowed to participate, my lord. They issue
Today the last day. They have not debarred you as of now.
because they say now new clause
There is a new clause. Show us.
There was, my lord, there was no clause in the previous.
ସେ ତ ନାହିଁ ଏଥିରେ କୋଉଠି ଅଛି?
Actually, this matter has become infructuous. That's it.
No, no, no.
Wait.
କୋଉଠି ଅଛି second clause ଟା?
Where is the clause that put a fetter that pending
ଦେବାର୍ଥ ବୋଲି.
the matter sub judice you can't.
Pendency, that is 12 years.
Because my lord, they
Where is the clause?
same ground.
Where is the clause? To us that you are debarred from participating.
They disqualify on the same ground, my lord.
Sir, where is the clause that you cannot participate? Till date, you have said that you have not been debarred. Only a show cause is given. You have given a reply.
Yes, my lord.
True, the matter is sub judice.
Yes,
They have
my
not
lord.
taken a conscious decision. Is there any clause that pending decision you are debarred from applying? I don't think so.
There is no such clause, my lord. But they
Then
disqualify.
go and participate
Today is the last day.
because that becomes a single bidder.
Yes,
and
my
they
lord.
cannot proceed on a single
No,
bid.
but they disqualify me on the same ground, my lord.
There is no disqualification now.
But they are not, even I participate, my lord. They again same
No.
ground, my lord.
How do you anticipate?
You are really proceeding on the
That
basis
liberty-
of assumption, presumption.
Then that lordship last
No,
date.
the last date has gone.
No, no,
Today is the
today.
last date, man.
Huh?
22nd is the last date for
Submission of
Last
Submission.
date is today up to
Go
5.
apply.
that liberty
What
of
liberty?
because
Minor
they
because-
same ground may they reject me
What same ground?
because I am
Yes.
qualified.
Whatever.
page 23.
Yes, it's no देखिए only 23 they only that mention.
Have you create? Have you included any clause that pending?
No, Miller.
Nothing.
No such.
So there is no fetter on the part of him to participate.
You can apply online.
They
He
reject.
can apply.
They only reject of rejection, my lord. That's the due to
No rejection. What rejection?
yes annexure 23 my annexure page 23.
Page 23.
What 1023?
That my ground of rejection, my lord, in the IA.
Yes.
That is page 24, my lord. Running page 24 in the IA. MS Vision Medical Equipment Limited was debarred by the DGFS for the that is X-ray mobile high frequency machine 100 MA. Hence the committee
That is the specification, sir. You'll have to conform to the specification.
yes that is 100
If
MA.
you do not have a specification,
No,
you have the
We have specification.
whatever you see.
We have
If you apply, they will consider.
that is we apply for 500 MA, 300 MA, my lord, not
I do
100.
not know if
Yes.
their specification is 500. If your is 300, they are within their
Yes,
authority to
it's
reject
specific.
it.
That's-
Specification.
Sorry, as per
We-
the
We have
specification.
specification.
yes.
That's all. The challenge was made to the tender.
may be adjusted.
But earlier EMD may be adjusted
in
if
this- if
petition
we
kits
apply.
apply, my lord.
If you apply the EMD,
Previous EMD may be
maybe
adjusted.
adjusted.
There.
This much I think.
My
Sin Lako.
If
Disposed
applied.
of a RATHO. The in view of the
Item number
Today is the
2.
last day, man.
all parties shall act on the basis of a server copy of this one.
Today is the last.
Item number 2.
Yes, what is this?
Alleging non-compliance of the order passed on 9/8/2023, the present contempt has been filed. But the direction was given to the OP number 5, Cuttack Municipal Corporation, the present opposite party number 1.
Can I, you are, who is for the petitioner?
The petition.
I'm really surprised with the prayer. Who is the petitioner? Mr. S.B. Mahanti? Yes? Dismissing? None appears. Dismiss for different. Record is appeared.
Item number 3.
My lord, in this case, state as well as union to file the counter. So many dates already 6 months past, they are not filing.
See, if they decided not to file, we can't wait.
My lord, I'm sorry, my lord, I'm busy. In this case, I have received the instruction and will file the affidavit within 10 days.
No, sir. Many a times
Because I've taken time, I've received the instruction. If Lordship want, I can produce this instruction itself from the court for a kind perusal. Information is ready, but they are not giving a proper format. I have to give a proper format for according to our High Court rules.
File by Tuesday. The last chance.
Yes, ma'am.
Tuesday. It is submitted by the learned DSG that the instruction has been received. Instructions have been received.
Item 4.
Same.
They
Yeah, please,
received
Lord.
the instruction from the office of the collector. May I pray, can it be taken up on Tuesday? My lord? I'll produce the instruction. Madam. Today I'll receive.
Well, here my the difficulty of the petitioners that this is a public interest litigation. They have ready with making construction over the land which is meant for the communal.
If it is illegal, if it is wrong, it will be demolished. There is no difficulty.
Well, that is right, my lord. Once it is constructed, then it will come multiple.
Then read that off-putted judgment of the Privy Council in Israel versus.
No, no, I am.
There is no fetter on the part of the court.
Only on Tuesday, madam. I pray. get the
The
instructions.
instructed matter to appear on Tuesday.
My lord, Tuesday.
Item 5.
May I please, Your Lordship? Madam, this is a public interest litigation filed to give a direction to the OP number 5. The Tahsil is to close an illegally operated brick kiln in the Sergad Tahsil. I have annexed those photographs at Annex 1, my lords. The difficulty is that there are two schools are operating within 50 and 17 meters. And there is a blind school also there. And by the Annex 2, we have made a recommendation, but no action has been taken since 6 months.
For that, the public interest litigation.
The petitioner is the Sarpanch, my lords.
Can he maintain?
Let's see.
And other petitioner co-villagers.
Can he maintain the PI?
Yes, my lords. Because it's affecting the whole
already-
village.
Yes,
I am asking you
yes.
that whether
We-
the Sarpanch, who is an elected body, is an elected person, whether he can force.
When is
Not
the
sure,
judgment?
my lord, on that point.
We have passed.
I will pass.
But there are other co-villagers also.
Mr. Makathra, we had already passed one judgment. This bench. Sarpanch.
I will provide
Cannot.
that judgment.
So still, my lords, it's a PIL.
Public interest litigation cannot be in this way. A representation is filed, consideration of the representation, public interest litigation.
No,
I'm at loss. I do not understand. Maybe my wrong understanding of law. Convince me. My mind is open. I am ready to accept. If I am wrong, I am wrong. I am bold enough to accept. I am wrong.
Yes, boss.
But you'll have to convince.
My lords, can you see para 9?
Can it lie at the base?
I'm not sure, my lords. So there's,
Then we'll have to, because we have already delivered a judgment.
may I prefer adjournment of this matter.
May I submit one thing, my lord? My lord, now the petitioner is the Sarpanch, my lord. Section 55 under section 55 of Odisha Gram Panchayat Act. There is
I
a
know
provision.
there is a consent of. Sir, why I am asking this question? I know it. The earlier Sarpanch who was there must have given a consent with all the villagers. He is now newly elected. He wanted to take this. I understood why you wanted me to disclose what is well known.
my lords, I may be allowed to withdraw this matter.
Understand?
I'm praying for withdrawal of this matter and file a fresh petition.
Withdraw. File a memo.
Yes, lords.
Item number 6.
It's, my lord, not covered by your lordship's direction. That's at 51 imposition of penalty by the
A
Tahsil.
little bit difference.
Little bit difference is that
That is confined to your brother.
yes, here,
Your
my lord,
brother who had no license, but this person has a license.
no,
Yes.
he became successful bidder, but the mining I have stated at paragraph at page 5, my lord, the mining lease has not yet been executed in his favor due to want of environmental clearances. That I have stated, Katak. So there is no mining lease as on date.
Lordship, may kindly see Annexure 3. Annexure 3, this notice was issued to all three of them, including his brother Ashish Yadav, in which case your Lordship have already passed the order. So in case of petitioner, same order has to.
Yes.
No, that order we have passed for 3.
3, yes.
So now
Ashish
it
Yadav,
has come for 2.
2.
Same notice. Yes.
I should have made some correction if your lordship permit me.
Corrected.
Yes, ma'am. Privileged.
Yes.
Item number 7.
Where is the other one? Where is the other one?
2 have come. 1.
The other one is actually previously.
He is in contact. He will come.
No, my lord, I must say. He has previously.
When you tried day for
he
yesterday,
was
then
previously
now
here and he has been relegated
brother-
for appeal.
Yes.
Item 7, ma'am. May I please lordships? It's a tender matter. In this case, after submission of tender, they have issued a letter under Annexure 4, my lord. In that letter at page 41, requested the opposite party number 4.
Yes, that is the procedure,
My lord.
negotiation.
My lord. But he has quoted 6.49. I have quoted 9.99. Other also.
So it's a matching. It's a matching. If we can match, then the entire contract can be bifurcated into 2%.
Just 2 days after, my lord, under Annexure 4, they have issued another.
That is what in all the tender process, there is a matching provision. They do it, a matching. To have the best price.
But the petitioner quoted 9.9. He has quoted 6.49. He has been requested to.
He may agree to come at 9.99 as well.
But I have already quoted 9.9. I have been not requested, not given letter to negotiate. I have already mentioned.
You will also get an opportunity. If he goes and says that I am ready to go by 9.9 or a 10, you can go to 10.1 as well.
Here in the, on the that has been issued on 9/6 on 11/6/25.
Best price. They have.
After under Annexure 5, they issued another letter for transparent lottery system. Now, as saying that there is a tally with the tender prices, but there is not tally.
Are you ready to go down?
My lord.
Are you ready to go down more?
My lord. I want to participate. My lord, sir.
He has come and matched your rate.
My lord.
So now they wanted to have a lottery.
My lord.
Correct?
My lord.
Are you ready to go down, vary your price? Can you go to 10? That is what is the modalities.
My lord.
To have the best price. Can you go to 10?
There is no condition, my lord.
What condition?
Regarding base price. Nothing. No.
That is what is required, sir, under the tender process. If they can definitely go by a best price. If you are ready to reduce more, we are passing an order, giving them that once they have adopted this mechanism of calling the other bidders to match the best price, then in that event we will also say that you are at liberty to go for a better price.
But with your purchase permission in this
I am
matter,
agree to
we have a fight. The successful bidder, the agreement.
You are not a successful bidder.
Milord, the agreement has been executed in writing.
That has to go. There's a wrong exercise that has been done.
Milords may kindly have their annexure 3. Milords may
Sir, at the time of submission of the bid, you did not quote the price which would match to it. They have gone and wanted to negotiate that whether that can be done. There are two ways which I understood in the.
Milords, I may just.
May I please your lordship? The tender has been noted, my lord. The tender for supply, installation, commissioning, UG Maniki for the different medical.
What is your grievance, sir?
My grievance, my lord, in the tender call notice, as for the guideline issued by the central government as well as the state government, my lord, the not given the preference to the micro, small, medium enterprises holder, my lords. In the tender call notice, my lord.
Yes.
Say guideline is for, my lord. The lordship may kindly say time to time it has been circulated by the central government and the state government pays 100.
That is the policy.
Policy, my lord. Yes, my lord. So,
but the government.
Government,
what it says.
So, Milords, there is a policy, Milords, there is a office memorandum and Milords, the procurement policy for Milords, micro, small, medium enterprises in 2012 central government as well as the 2015 state government, Milords. Is that been preference given to the micro, small, medium enterprises holder, but there is not in the tender call notice.
When it is floated.
Milords, the tender call notice page 30, Milords. The entire tender call notice, there is no clause, Milord. The given purpose.
What is the tender?
Tender, Milords, the annexure 2 series, page 30.
2 series.
2 series, page 30.
30.
Yes, Milord.
Page and relevant page.
Milords, the page 30 is the starting. Then, Milords, the page, let's you may kindly see the page 44. The time limit prescribed and onwards, Milord. It has all the clauses have been there, but in the said clauses, neither nowhere it has been mentioned the given the preference to the micro, small, medium enterprise holder.
And where is the policy?
Milords, let's you may kindly see. That Milord first. Let's see at 102, page number 102, Milords. Office memorandum issued by the Government of Orissa Finance Department. May I permit it to place, Milord?
Yes.
With a view to extend.
Yes.
Milords, I'm sorry. Sorry.
So no preference.
Yeah, Milords.
Does not. It's an exemption to file the MD.
Let's see 104 also. Time to time, Milord, circulate 104 also. May I kindly see. See, relaxation of norms for startup and micro and small enterprises and public procurement.
Central government.
Yes, central government circular, Milord.
That is also an exemption of showing the prior, the turnover or something.
No, Milords. That in the clauses,
No,
Milord.
but what preference?
Preference. Lord, may kindly for a 1 by 1, Lord. 121 also, Milord. The central government guideline, Milord. Ministry of Microsoft. 121. Relevant is, Milord, 122.
Yes.
Milord, the clause 3. Mandatory procurement from micro, small and enterprises.
Is there any exemption in this because it relates to a health sector where the quality cannot be compromised? Is there any exemption that it will not apply to a particular sector?
There is no.
Has to be.
Malas.
There are certain sectors where there should not be because quality is the important factor.
Yes, Lordship. And more particular, Milords, the state government also notified, Milord, the relevant page is 136. The page 3130, Odisha procurement preference policy for micro and small enterprises 2015 also, Milord. There is also, Milord, 136, clause 10, mandatory procurement from micro and small enterprises.
Yes. Why not? Because the condition is that the quality has to be at par with them. So why you have not included in because it is the this MSME Act also provides for that. It's a statutory compulsion.
Well, now the tender is floated by the medical corporation, my lord. Then this is to be solved.
Where is who is you are representing?
No, my lord, I am representing the government of India. Here, our notification has been referred and he has your notification.
Notice.
That is.
Sir, it has come to an end. Are you challenging now? Because the
No,
end time is
No,
sometimes
the
24.
subsequently, Miller corrigendum has been issued. Last corrigendum, 13 August
Have you
2025.
incorporated that?
No, Millers, that just.
No, you'll have to.
Lordship, may kindly see. Before that, Miller,
No.
it is 13. Lordship, may kindly for a moment. Lordship, for a moment. I have filed the writ petition, Miller. Lordship, my last date was fixed, Miller. Lordship, may kindly see. The 28/8, Lordship, may kindly for a moment. See, last date, 18/8/2025. Lordship, may page 87, Annexure 3.
387.
Yes, then subsequently another corrigendum has issued. Your Lordship, I beg apologize, my lord. Today, my lord, I got it, my lord, that I am unable to file affidavit, my lord, with memo.
You bring it. When is the last date?
Last date, my lord, the second bid is opening for 2nd September. Last date is 29th, my lord. Submission of bill.
And when that corrigendum is issued?
Yes, my lord, the 13th.
Huh?
13th August.
So what you were doing?
So, my lord, the last
What
date.
you were doing?
So, my lord, we have.
You could have come much earlier.
So, I'll incorporate it, my lord.
Today is the 22nd.
22nd, but your lordship, last date is 29. If
So what?
So, lordship, may
serve the notice where? This corporation?
corporation, my lord, Bhubaneswar.
Serve by
Special.
by hand, yes. Requisite file requisites today.
Malach.
Keeping this matter on Tuesday.
Malach.
On this Odisha State Medical Corporation. I do not know which opposite party.
Malach, opposite party number 3 minutes.
Tuesday. Requisites today. Yes.
Item 9.
Grateful.
Take it in the meantime, affidavit, bring it on record.
Lordship. Grateful.
Yes.
Here, prayer is very simple, Lordship. In fact, Lordship, state
What is this DPR, sir?
DPR, Lordship, detailed project report. Lordship, in fact, Lordship, only on the ground of jurisdiction is pending, but they are not doing anything. It can be transmitted to Lordship original authority, Lordship. Annexure 8, Lordship, can see page 47. Annexure 8 and 49 is the Lordship operative part.
Which one?
Page 49, Lordship, Annexure P.
Yeah.
Annexure 8, Lordship, page 49.
So the appeal stands dismissed.
Lordship. Then Lordship approve this honorable court. And now I have appeared before the opposite parties, Lordship, by giving the DPR there, Lordship. Now the sub-collector is, Lordship, sitting over the matter. In the meantime, Lordship, now the appellate authority is, Lordship, deputed at minds. So record can be transmitted, he can take a decision, Lordship. Here, Lordship.
What he says, I fail to understand.
Lordship, during filing this appeal, sub-collector was the appellate authority under the Lordship old.
That is the 25/10/2022. This. So on that day, the amendment was brought.
No, well, amendment was brought on
Subsequent that too.
27th December 2022.
So at that point of time, he was.
And thereafter on 24th April 2020.
Again, Lordship, this appeal is pending with him. It will be transmitted to him.
Not pending. It is not. It is disposed of at page 49. The appeal stands dismissed. So there is no appeal pending.
No, Lordship. Then, Lordship, I had approved this honorable court. And Lordship directed to approach again the appellate authority.
Where
and
is
that
that
is
order?
divide, Lordship.
Where is that order?
Lordship, that order, Lordship. That is at Lordship, page 14. Page 14, para 15, Lordship. Order dated 9/3/2023. Page 15, Lordship. Para 5, Lordship, that is. As agreed by the learned counsel of the parties, and after going through the record, this court is that expressing an opinion on the merits of the case disposed the writ petition died out of 3.
Yes,
to
madam.
consider.
Yes.
Sorry.
From where this concept has come? An appellate authority has decided the proceeding. Finally, if anybody is aggrieved, he can challenge that. Where is the concept of a representation when there is no power of review, when there is no power which is there? What is this? Can he review his order?
His lordship and he is considering lordship. After this order lordship, the appeal has been lordship reviewed and he is considering lordship.
Take out in contempt why the writ petition should come.
Now lordship only reaching lordship because he is not the competent authority. Now lordship law has been amended. Now the deputy.
The writ petition was filed in 2023 only after the amendment, and order was passed to consider the representation.
You did not point it out. You should have said that under the statute there is no provision for a review. What is the purpose of the representation? Under what provision? And in a mechanical manner, representation to be decided. If we pass an order, what he is asking for, we will be doing a further injustice. And illegality would be projected and evident. Can a mining officer act as an appellate authority of the sub-collector who was vested with the equal power?
Not at all.
Same power?
No, not at all.
The difficulty is
and the
judicial discipline, which troubles me.
And he wants the annexure 10 to be reconsidered. Annexure 10 is again addressed to the sub-collector. That is
immaterial. Yes. That is immaterial when the authority has changed, forum has changed. That does not mean that the content would go or the right would go. Right gets fructified because of the order of the court.
Even by consent of parties also the jurisdiction cannot be.
Sir, I am
that your lordship.
Jurisdiction in the court, which it inherently lacks.
And the amendments I have given that amendments for finance.
Yes, my brother will pass this.
And that order, the order passed by the sub-collector also attained finality because.
Sir, no, it is why you did not point it out on that day.
Not.
You should say mere representation does not revive any right. The right is already there. Either you decide the order of the appellate authority is correct or not. Either affirm or reject. When there is no power for review, Is there any power of review then? I can understand the representation to be treated as a review. Brother, take this. Just putting that earlier order, which is
Should may
15 or 16 of the rate petition, what can be done? The sub-collector is sitting tight over the matter. Despite this, for the simple reason that the amendment has been brought in the meantime, then on the separate. And therefore now the authority is a proper opportunity. So, yeah.
if my lords may have a relook into the prayer made by the petitioner, he wants quashing of the order of 2022 in the present writ petition. The lordship may kindly see prayer at page 19. He wants quashing of the order of 2022.
That's fair. We can enter.
So after
We can enter. But because of this intervening order, what can we do? He challenged that order, but the court has relegated him to the authority where he's saying that his representation to be decided. So he can't be put at fault, and the authority is not deciding anything.
but whether it has been decided or not, let me take instruction if it has.
Nothing is decided. You can't decide it even now.
Yes.
When the order was passed, your authority already ceases or ceased.
But whether they
Cannot.
have taken any decision or not, that
They
is
can't.
they cannot. But if
So it's
whether
the mining officer who will decide. Transmit.
Deputy
In
Director.
terms of this representation. Keeping all the point open, maintainability and all, everything we are keeping it open.
only that representation. If it is pending with the sub-collector, then
It will be transmitted to mining officer.
Yes.
He will decide everything,
yes.
including whether it lies or it does not lie, and all everything is kept open for him to decide.
That may be clear.
We'll make a clarification.
Fine.
Yes. Yes, next.
Item 10, may please your lordship. It's a small grievance, my lord. For
He'll pass the order. Don't worry today.
Only I pray that 2022 order may not be that.
What we
only,
said,
only the
what we
representation.
said
Yes.
that representation is
But-
gone. There also they did not.
Yes.
We will not say, but we will put a rider
My lord.
that it is open to him to decide all the points, including the maintainability of the representation. Everything he will decide.
item 10, may please your lordship. It's a small grievance, my lord. The for requirement of the tube well for the purpose of common use in the Harijan Pada Basti, my lord, which has been
What
dismantled.
is the common use of?
Common Basti people's my lord.
What use?
Tube well,
Okay.
my lord.
I did not hear that word.
My
That's why.
The petitioners and as representing my lord.
They are not repairing it.
My lord, they are not repairing. That is
Why?
what
Why? For that,
for the
the
common
villagers the Basti peoples have to come.
My lord, they're saying that, my lord,
The water is an essential elixir of life.
see, the tube well was established in 1986. This same has been.
This word now cannot use.
Pardon?
This word you cannot use.
What?
I didn't hear him. Oh, he has written. Sir, what is this? Why you are using that word? Now the apex court has also published a glossary of words. Certain words are not to be used in a judicial section. And
I'm sorry, sir.
this was the reason when the cost at the time of making of the constitution, the Constituent Assembly have taken an exception to this.
Sir.
And even an SC/ST Act also says that utterance of this word is a violation of that particular in a public. And you are
I'm sorry.
making a pleading of that.
I'm sorry, sir.
This is not expected. I didn't know.
Yes. I've just.
Do you understand what we mean? What word you have used in your petition?
Petition.
Yes, that is why my brother is saying, don't utter that word, but just read that word.
Cost title.
Don't
Cost
utter.
title, my lord.
Cost title.
My lord.
Second para. Second first.
Repairing the
communal tube.
That's all. Thereafter, don't utter that word.
Yes.
Can you use that word?
That is name is there.
No.
Name.
You should be careful. That's what we are saying.
They are calling the
No.
I got to
No.
I got to
No.
loss.
You are a lawyer. While drafting, you should be very careful.
My lord.
It remains forever.
I got to loss, my lord. But that is common. They are calling as well.
Whatever. Why?
I beg apology, my lord.
This is a derogatory words.
My lord. I got
it demean a particular community. It demeans. No, it's not. Anyhow, why you will?
Let's see paragraph 5.6. They say that opposite party number 7 has consciously destroyed the tube well.
Who is this opposite party?
He is a private person that has also been narrated as OP 7.
Whatever.
In March,
will you repair and install?
My lord, we'll take steps to repair it.
Immediately take steps. Sorry. We are directing you. Please
file a caveat petition, my name has not come in the cause list. He has served copy on me. So I pray 1st September, similar matter is fixed to 1st September.
No, my lords, if I may be corrected by my learned senior, but similar matter yesterday, item 8 is fixed to Monday.
Monday, yes, Monday 1st September.
My lords, can I make one humble prayer, my lords? Caveat, the copy of the caveat was served on Monday. So in the meantime, if the count to be filed, my lords can hear the matter. No, my lords, because we are assigning the entire process of initiation. They could not have.
I'll take instruction. I'll try.
Come on, date. Yes, next prayer, Monday.
In the meantime, they'll take instruction.
Yes.
Very grateful. Item 12.
Where is the order dated 2/8?
My lord, in response to the tender call notice invited under Annex 2, lords, you can see page 26. The value of the work is 111 crores, more than 11 crores, 11 lakhs, 8 lakhs. The tender was
You are challenging the order
of cancellation.
the decision of cancellation and Annexure 7.
My lord.
What ground?
Ground, my lord, because there is a specific provision under the OPW code that whenever the value of work could be more than the 10 lakhs, the administrative department has to take approval. Here in the case, lordship can see the financial assessment page 70.
Same question.
No, my lord, page 70A, my lord.
What is the applicability of the code?
Regarding OPW, my lord, I do admit, my lord, that is executive instruction. But when there is no statutory specific provision, but we are bound by the tender conditions that is stipulated there.
Decided to cancel, then they will go for a fresh.
This is third occasion. This is third occasion this tender has been cancelled for no reason. Your lordship has moment being my lord's notice. Page 70, my lord. The administrative department, after technical evaluation, has given a approval. Again,
Why you are cancelling?
At page 76, Millard, they have referred to one letter. That letter, my learned senior has not filed with this petition. I will take instruction, Millard. Inviting
Annexure 7 is their letter.
in inviting a reference to a letter number so dated 18/1/2025, Millard.
Where is the 18/1/25? You produce.
Yes, Millard, I will produce. I will take instruction.
Come on Monday.
Can it be on Tuesday, Millard?
Tuesday, let him come with the
public.
Item 13.
May I please, Your Lordship? My lord, the petitioner seek to challenge the propriety of the tender call notice, the 2/8/2025 Annex 1, Millers. The tender submission date was 28/25, but I am instructed that has been extended by 7 days, Millers. The ground of challenge, Millers, the present tender call notice is inconceivable and impracticable, more particularly in the specification of items in respect of which tender has been called. In that regard, may I invite my lord's attention?
They wanted a medical device 42 license from a competent authority.
Yes, my lord.
What is the grounds? Orthopedic implant items.
Orthopedic implant, my lord. Page 15, may I invite my lords? Third line, your lordship, kindly see. Page 15, third line in the
page 15.
Page running page 15, my lords.
Yes.
Third line in the table, my lords, starting with the words IMP 0542, orthopedics polytrauma. Implant name is 1 6-hole small DCP with screws, my lords. My lords, in this
IMP
0542, running
first one.
Second item, second one.
1/8.
My lords.
542.
IMP 0542. First item is 0541, second item is 042. Orthopedics polytrauma, 1 6-hole small DCP with screws, my lords.
Correct.
So my submission before lordship that in medical implantation, my lords, in emergent situation, varying specification of implants are required. So they have mentioned with 6-hole small DCP with screws millers, but there is no mention of varying number of holes like 4 holes, 6 holes. It is not there. And in addition to that,
No.
millers.
6-hole.
Yes, millers. But in
6-hole is there.
6 hole is there.
So
But in emergency situation, there are varying requirement millers like 4 holes,
are you
8
an
holes
expert?
millers.
Sir, are you an expert? If the surgeon at the time of whatever the surgery, if he wanted to implant this and he wanted a 6-hole, then a 6-hole must be made available.
In addition to that, my submission 6 hole has to be there. In addition to other variation has to be there. In addition to the my submission.
They may not be requiring.
Another thing.
The author of the
May not require 4-hole. Why they will require 4-hole?
Another submission millers in supplementary submission millers.
Yes.
For implantation of these screws millers, they have mentioned screws, but along with the screws, there are requirement of small drill bits with single disposable drill bits, without which the implantation cannot be possible.
Sir, they are there. They must be having. They do not want. You do not know how the advanced surgery has come. You have no expertise, sir.
But my submission.
You may be a manufacturer of a particular goods which may now, by passage of time or a development or advancement or an invention having come, becomes obsolete. Why they will go with the obsolete things? They wanted a modern technology to be adopted.
My lords,
Screws maybe they wanted.
But
it is their requirement, sir. How can you impose?
But I don't know impose millers. My submission is that they come in packages. The screws along with the drill bits, they come in packages.
Whatever you supply, whatever you supply with them, they may not use it. They wanted simply screws. They may not use any other device.
So there will be difficulty in the billing millers. The difficulty will be in billing millers. If they come in packages miller, it is inconceivable that the screws will be fitted without the drill bits.
No.
That is
up to them what they want to do. You can't.
Millers.
That cannot be. That cannot be.
And millers in the 16 line also millers.
No, it's expertise.
There is another millers item 0590 recon plate, but there are varying millers
orthopedic
millers recon plate millers.
Yes.
There are 4 type of recon plate. They have not mentioned what kind of, what is the specification. They have not mentioned. So it is not.
They will take care of that.
It is not possible millers to comply.
No. They will take care of that.
Millard instruction may be called millers.
My lord, the petitioner,
Notice
the
may be
petitioner has not stated in the writ petition, my lord, why he has filed this writ petition. What is his locus standi, my lord? Whether he wants to participate in the bid or not, it is not stated. It is just like in public, just like this. My lord.
She can't declare it as an illegal. So this is what is there. Their specification. They are the expert. If they want a particular instrument or a gadget, it is up to them how to do it. You are not there supposed to advise unless you have an expertise in it.
Millers, I am not imposing.
Who are you? What is your locus standi?
Millers, I am one of the intending tenderers. Millers.
Are you a manufacturer?
Yes, I am. Millers.
What you manufacture, you supply. If it comes, if you are eligible, participate.
Millers.
That means.
That Liberty Millers.
No, Liberty. When is the last date?
27 Millers.
Go and participate.
There's one line Millers here.
Participate.
Liberty may be granted.
What liberty? That liberty is always open. Sir, the tender last date of submission has not expired.
Yes.
But apply. But we are not going to. Brother.
Notice may be.
Yes.
Notice may be government.
You are not an expert. Yes, record.
Item 14.
Obligement.
May I please yours?
May I please, your lords. Like, here is a case, my lord, in the standard bidding document, there is just the inbuilt procedure. After opening the part 1 technical bid, the bidder, a right has been created in favor of the all bidders. They make a grievance to the tender authority within 5 working days, and they will decide before opening of the part 2 financial bid, my lord. And that is clause 22.6, my lord, annexure 2, page 35, my lord. And the price technical bid was open on, my lord, 14 July 2025. He made a grievance that some bidders has made a false document. So within 18 July 2025, within 5 days.
Specify that what false, which bidder has given what false document.
Yes, I specified, my lord, detail. Okay. So, my lord, they are now going to proceed price opening of price bid instead of complying 12.26, my lord. That is my.
Where is the clause?
Your lords.
Page
Annexure 1, page 35, your lords.
35.
Your lords. Clause 22.6, your lords.
Yes.
The result of the evaluation of part 1 of the bids shall be made public on e-procurement system, following which there will be a period of 5 working days, during which any bidder may submit complaint, which shall be considered for resolution before opening of the part 2 bidding, my lord. And your lordship, annexure 2, your lordships, your lordship, they have page 95.
And your objection was within 5 days.
Within 5 days, my lord. That is annexure.
Yes. Yes, sir. How can you? If you have incorporated it, how can you proceed?
My lord, now let's kindly turn to page 16, my lord. As per the tender document, the time and date for opening of the part 1 bid that was stipulated to be 1/7/2025, and his objection is dated 18/7/2025.
Come to annexure 2. When you have opened. On 13/6. Notice dated 13/6, participation opened.
Yes.
It is 14/7, my lord.
Oh, it was done on 1st.
Your lordship, kindly have page 96. The annexure 2, it was open 47. They also specified within 5 days. Page 96, for the last paragraph. Further, it is stated that the grievance in respect of the result of the technical evaluation by the aggrieved bidder, if any, must be lodged to the answer.
Within 18.
Within it. So I am within 18 minutes.
Yes.
Yes, my lord. Now, my lord, here, my lord, it is time is also fixed up to 5 p.m. 18/7/2025.
So
now, my lord, at page
email is
yes, page
timing?
99, my lord. Timing is not there. It's
No, it is there. Right, right column. July 18, 4.7 p.m.
Where?
It is page 99, right side, your lordships.
It is not legible in
not legible. Lordships, the page 99, last Friday, your lordship,
Yeah,
Friday
yes.
is 4.77.
4:07 p.m.
4:07 p.m.
Yeah.
19 page
Yes,
99.
yes. 4/7.
It's not legible in my copy. That's it.
Not.
Please.
Yeah.
07 p.m.
I've given the e-copy also.
Then, my lord, I will take instruction.
Instruction. Don't go for a opening any. When they are going to open.
My lord, as per instruction, they today, but not yet open, my lord. Today, my lord. Today is not open, my lord.
It is not going
It
to
not
be
yet open, my lord.
Not going to be opened today.
No, not open, my lord, today.
So they can open it.
Yes, my lord, they can anytime
At
open.
any time.
Anytime, my lord.
By now it is not.
No, not open, my lord. As per today morning instruction.
I will inform the department not to open it, my lord, and to take some.
Before
Take
you
some
Immediately you go and inform.
Yes, my lord, I will inform.
you can.
Monday. But this is absolutely clear from this.
Yes, my lord. If they have already informed, they should have taken some decisions.
Legible copy, please.
I'll
give
copy one.
Page 99.
I'll
Legible
share
copy.
also, so WhatsApp and so. Oh, bless.
Yes.
Can it be taken up on Tuesday?
Monday.
Okay, that's fine.
Oh, bless.
Lord, I am National Highway Authority of India.
and I'm a government authority. I'm not a registered either under the service tax regime or subsequent to that, the GST regime. And therefore, I have never paid any service tax, nor even the GST post 2017 regime. Now, for the first time, this particular demand, as a class of demands, now they're imposing not at the stage of, they call it as a service, that is, the maintenance and the constructions and the management of the highways. For the first time, they say that the amount that I have received on account of the earnest money deposit, which I encashed on account of non-performance, like liquidated damages, bank guarantee, that amount they call it as a consideration, and they are charging the service tax. That's the demand which is before my law. So, as a government authority, I'm outside the jurisdiction of the service tax regime, never charged it, and in the impugned order also, they have not even discussed that at all. The relevant paragraph, if your lordships will see, page number 17. 17, my lord. This starts from, my lord, the page number 16. That is the discussion and finding. And the relevant portion, my lord, page number 17, paragraph number 2.
Why have you delayed in approaching this court?
My lords?
Why have you?
What is the date of the order?
Well, the date of the order below the 30th, below, that's the date of hearing, 30th of August 2020. That they issued it, but they issued it much later. And in the meantime,
when have you received?
My lords?
When have you received this demand notice or this adjudication of law?
This is over 2024.
My lord,
30th August.
but the concerned officer, the person assigned.
GST Act that you are exempted from the purview of the GST.
My lord, I'll show it from the page number. GST Act is the 2017 onwards. There is a notification which, in fact, the coordinate similar matter, my lord, is coming up on Monday. The similar matter, but that is with respect to Kampa. That's a statutory levy which I paid at 200 crore under the Forest Conservation Act. On that amount, they have levied about 80 crore, 85 crore. By not only levying the GST as well as the penalty as a matching amount. And this is also the same story below here. The service tax as well as the matching penal amount.
Service tax.
This is below service tax. This is pre-2017 regime. That second matter which is coming up on Monday, as I was told, it's already, your lordship's last time it was listed and your lordship posted 25th. That also is with respect to this GST regime and the similar demand they have raised.
So let it come on Monday together with that.
Yes, my lords.
My lords, if I may clarify, my lords, I have appeared for the department, my lords.
Yes.
That collection of Campa as a service is a separate issue altogether.
Oh.
This is, my lords, here, my lords, the petitioner is claiming that he is getting a blanket exemption merely because he's NHI. My lords, the amount that has been collected by NHI towards tolerating breach, towards EMT and cancellation.
There is a question of one thing, that if they have secured a performance bank guarantee or a security amount to ensure that there is no default on the part of a contractor or a service provider. Then in that event, if he has, they have invoked the bank guarantee or forfeited the security deposits, but that would attract, because security deposit is something, it has a different notion.
Lordships may come in, my lords. My lords, I'll respond right away, my lords. My lords, the
Not a part of the service, the charge. It does not come under the service charge.
My lords, at the outset, my lords, this notification of 2012 that deals with, that's not a blanket notification exempting NHI and governmental authority. NHI gets exemption towards works rendered towards construction, erection, and maintenance. This is outside the scope for tolerating breach, which is falling under the scope of declared service under Section 66C of the Finance Act. That is the manner in which the department has invoked and has levied that service charge. This is for the pre-GST period from 13 to 17. This is not a blanket. As Lordships knows, taxing statutes have to be interpreted strictly. This is not this is not a case where it has been levied on the construction activity of NHAI. This has been levied, my lords, on other kinds of services that have been rendered, which are falling within the scope of 66E of the declared service.
Towards the definition of a service,
Lordship.
whether security deposit which he has taken or a bank guarantee which is given to him in due performance of the contract, whether that comes to the services, because it is really a compensation or a damages which he suffers to be compensated, nothing more than that.
My lord, subsection 22 of section 65B will clear that doubt. That defines, my lords, the declared service. What it says: any activity carried by one person for another, for a consideration, and then it is declared as, my lord, the declared service, which is 66D, which my learned friend is saying. 66E.
The element of consideration is absent.
This is one. No. It says again, my lord, any activity carried on by one person for another, for a consideration, then it is a service. Subsequent, my lord, to that, it should be declared as a declared service under section 66E, which my learned friend is trying to read 66E, subclause E, but is not reading the 22, which I am reading it out. Your lordships may see that. Declared service means any activity carried out by one person for another for consideration. That means there should be a activity A, B, a person should be given that activity for another person, and the third, that should be a consideration. These are the three parameteria for the purpose of the definition quote unquote. And service is also separately defined. That's in subsection 4. So here is no activity. Even if they treat it as an activity, saying that encashing an amount qua a liquidated damages is an activity. A. B. Is it that activity done by one person for another for a consideration? Me, I am a government entity. I am already exempted outside the purview of the statute. That is 66.
Not a blanket exemption, my lords. Not a blanket exemption.
All right, my learned friend, as 66E.
Lordship, I have 66E.
D for a moment, Bala.
66E.
66 negative list. 66D for a moment, if a lordships may kindly have a look at it. It says that this is a negative list for services, because definition of a service is subsection 44 of 65B. It says three things: A plus B by the C. A is what I have read it, plus B is actually the 66E, that's a declared service, minus, that is the negative list. I fall on the minus, that's the negative list. So may I just read it for a moment?
That has to be read along with the notification of 2012 notification. It can't
But
be.
that notification is an exemption notification. You are borrowing the language from the notification and putting in a substantive. But that's a very peculiar situation today.
They're only getting exemption for construction, erection, and maintenance.
2012 notification is exercised by the central government under section 93 for the exemption for those people who are already covered. So what he is doing, what the government is doing here, department is doing, borrowing the language from the exemption notification to read into the substantive provision to say that you are exigible, and that the provision is 57, which is happened in 2016. That's a modification of 2012. And then post 2016, after 1.5 years, they issued the notices and thereby demanding all these amounts. That's a very peculiar. I have actually brought about my lord, the written note for my lord's consumption. I've drawn also a Venn diagram.
For the statutory period, my lord, statutory appeal period, they have come here before this honorable court. This is an appealable order. And if they are aggrieved by this issuance of the notice, my lords, that it was without jurisdiction.
There is an issue. This is an issue pertaining to the very jurisdiction or exercise of power.
Yes.
Then in that event, report.
I bow down, lords, but they should have come, my lords, at the place of show cause notice. After the passing of the adjudication order, they should have come here, my lords, at the time of issuance of show cause notice. I write
honorable exercise of power then.
Mr. Mahapatra, if it is, he is not falling within the purview of service tax at all.
I'll satisfy, my lords. It will fall, my lords. I'll satisfy.
And that is what he is bringing up.
66E, my lords, I'll not press maintainability for a moment. Only reason I was trying to press is that because he's come here after the statutory period, lordships may have declared services under section 66E and clause E, my lords. This is falling under the scope of declared services, and that is what the department has invoked for issuance of show cause notice and passing of the order.
This E,
My
it
lord,
says, agrees the obligation to refrain from an act or to tolerate an act or a situation or to do an act.
Grateful, my lords.
What is this?
My lords, here, my lords, the way it has been interpreted, my lords, by the commissioner, my lords, passed that adjudication order, is that, my lords, for the issuance, for the collection of earnest money, collection of the penalty and liquidated damages, is an act which is falling within the scope of tolerating the act of the particular contractor.
Sir, there are many distinctions are multiple. And earnest money, a money which is a part payment of the entire services, or a money which is considered to be a part of the consideration. I can understand that those can be brought within that purview of this, but suppose a security deposit, which after the successful performance of the entire contractual obligation is liable to be refunded to a service provider. It does not add to their asset, nor they can utilize that money for their own purposes. Does it come within the purview? Because they are simply a custodian keeping as a security in the event if any lapses comes, they can remedy that particular, the liquidated damages which they would suffer. So it all depends that how they have to treat it in this way. Bank guarantee, the money does not go straight away to them. It is kind of a security or an obligation which is given to them. In case there is any default, they can invoke and get that amount.
Lordship, I quite understand what is falling from your lordship.
Cannot come within the purview of
Lordship, I understand. Lordship is considering a situation where, my lords, the security deposit was collected and it was refunded subsequently. Therefore, it will not fall in the scope of consideration, my lords, if I have understood your lordships correctly. Here it is a case, my lord, 66E.
Oh, please, I am saying that is what I am trying to understand from the both of you.
My lords.
This is what would be the nature? Can you visualize a situation at the time when the contractual obligation starts?
Lordship.
This does not form part of a consideration amount.
Indeed, my lords.
It does not. It is outside the purview of the consideration amount. They are obliged to pay the consideration price for the work in its entirety, not deducting a single penny from the security deposit. They can invoke the security deposit only in the event of a default having committed, that too of the services which is not rendered.
That is exactly my lord's department.
Not
it is
rendered.
liquidated. My lords, this is the case of the department that liquidated damages and penalty that has been levied by NHI on the contractors. Department is seeking to bring it within the scope of Section 66E Clause Z, my lords. That is what his department has done, my lords. In this
That
case.
is what I could understand. I do not know. We have to then hear out the matter. To come on Monday and
Lordships.
Yes. No, what he says is that it has two parts. One is
Just like
come on Monday.
Well,
Lordships.
so obliged, bro. Your lordships actually put it more pithy, lord, which I could not have also done it regarding the lords as a consideration. Subsequently, it is only a subsequent actions out of the substantive actions which is part of the contract. Apart from the fact that it's not a service at all. Therefore, I am outside the jurisdiction.
Had it been arising out of construction, my lords, we would have had no case. It's not arising out of construction or erection maintenance.
That's what the Honorable Court said. It's forming opinion. Well, this is
One
the
after another.
other
Both
matter.
matters will not tag, but one after another.
I'll also examine, my lords, if there are any authorities on this proposition.
Please come.
Well, the writ petition.
Still, our mind is open. Don't
What's
worry.
it?
Well, that is a
Yes.
Campa. This is writ petition the other writ petition of 16657/2025. Submission. In this matter, there are 4 documents which are missing. That is in the impugned order from the page number 11 to 12. There are 4 documents pages missing. I'll give a fresh order to that effect, so that yes.
Give a copy in advance.
Hello.
Item 19. Item 19 pertains to 74B under service. Grateful.
Yes.
Item number 20.
Related to
From 21.
cancellation of RC.
Verified the order, necessary correction he has not done. He will go.
Please do that correction.
Item 22. 22 must be RC cancellation. RC cancellation. Item number 23.
And item number 23, I need 1 week of time because these appeals were filed by the Mr. Satpathy, who is now joined as the judicial member of the tribunal. The file has not been transferred.
10 days.
Being led by item 24.
This is that it's a covered matter. Your lordships let it come. WNT DMT the issue.
24. Yes. Yes. What is this?
24 minutes. This is 23 minutes. I was for the respondent.
He's asking for a time.
Yes.
10 days. So we have given it after fortnight.
Mileage.
Item 24.
May I please, your lordship. So here, I have challenged the order passed by the Honorable Single Judge, my lord, directing the petitioner to avail the alternative remedy available to him under the guidelines, my lord. So here, earlier petitioner has approached this honorable court, my lord. This honorable court has passed an order, my lord. Your lordship will find that in page 83, my lord. Page 83, The order was passed by Honorable Single Judge. Now place paragraph 43, 44.
You are a petitioner or respondent there?
They are, I was a writ petitioner, madam.
Writ petitioner.
Yes, madam. That was entertained by the
So the
coordinate
interim
bench.
order is also passed, status quo to be maintained.
Yes, that ultimately, my lord, the Honorable Court has directed to consider my case in terms of the guideline. That was not considered, my lord. Then I
No, in the impugned order.
impugned order, my lord. Impugned order is 136, my lord. 136.
I read the another order.
Paragraph 9, my lord. 130. The page. 130, ঠিক আছে. Page 142, my lord, you will find paragraph 9, my lord. It is apt to note here, in terms of the said guideline, the contract has been executed, the non-renewal of which is the subject matter of challenge for convenience of, but that is not my prayer, my lord. This has been misconstrued, my lord, because my prayer in the writ application, the lordship will find my prayer is at page 83, my lord. Sorry.
What is your prayer? Read.
No, sir. My lord.
Read your prayer.
In the of the writ application, my lord. Yes, madam. Page 36, my lord.
Yes, read.
The letter.
Read.
Yes, the letter number 1792 dated 3/5/2025 on Annex of 7 with regard to disengagement of the petitioner as well as engagement of OP number 5 and 6 issued by OP number 2 shall not be quashed. The OP number 2 shall not be directed to allow the petitioner to prepare and supply Chatua under SNP in respect of Balsar Municipality ICDS area as per order number such and such dated 29/3/2025 on Annexure 5 series as well as letter number such as on Annexure 6.
Why you were disengaged?
My lord.
Why you were disengaged?
Yes, my lord. Your lordship may see no reason, my lord, without behind my back this order was issued, my lord.
Was the engagement perennial or perpetual in nature?
No,
or it has a duration.
It is for 1 year, my lord.
So 1 year has expired.
1 year has expired, my lord.
And thereafter they continue. They have disengaged you and they have engaged him.
No,
yeah?
my lord.
What was the duration of your? From which date to which date the 1 year?
My lord, turn to page 106, my lord.
From which date to which date?
My lord, from 29/3/2025, my lord.
29/3/2025,
my lord. That was in this because that.
The starting date is 25/3.
29/3, my lord.
Starting date.
Yes.
Then the 1 year will expire.
No, that was not for 1 year, my lord. That was in mid because the order earlier order.
Your first engagement was when? First engagement was when?
The first engagement, my lord, I was terminated. Against that, my lord, I filed preferred writ application, earlier writ application. That was disposed of, saying the authorities to consider my case, my lord. And thereafter, in compliance to the earlier order of this honorable court, my lord, this order was passed.
I am simply means, sir, there are two things, sir. One is termination and another is expiration.
Yes.
I just wanted to know whether it is a case of a termination or it's a case of expiration.
No, my lord. It is not expiration, my lord. I was appointed on 29/3/2025, my lord.
That is what a starting date of your engagement and the duration is 1 year.
Duration is 1 year, my lord.
So means that 29/3/2025, if 1 year is to be counted from anniversary to anniversary, it will be 29/3/2026.
Yes, my lord. Yes,
Is it?
yes, my lord.
Then in the midst of it, it is terminated.
Yes, my lord.
When
22/4/2025, my lord. Sorry, my lord.
22/4.
It is, my lord, 3/5/2025.
So just after 1 year.
No, my lord. 3/5/2025, my lord. After 2 months, my lord.
That is what, just after 1 year, sir. April.
Yes.
And then the May is starting.
Yes.
So just after 1 year, sir. My mathematics is good, sir. 29/3 and 3/5.
3/5. It's
So how much? More than 1 year, not 2 months.
no.
So they terminated. On what ground?
Nothing, my lord. They say that the earlier order is extinguished. The language of this
Is
letter,
your
my lord.
engagement?
Yes.
Okay.
Who is for the state?
I'm appearing for OP number 5. Who are you? OP number 5. The copy they bring up to us. Who are you?
I have challenged
I am another SSG group. Oh, you have been engaged.
Yes, my lord.
Yes, give him a call. Then he has a right to a copy.
Yes, my lord.
Then he has a right to.
Yes.
Peruse, come on Monday. Yes. See to it. Let us see. Termination is there or not.
Yes.
Yes.
Next, I'm sorry, probably your lordship will be rising.
Oh.
But next matter I have
What?
number 25%. Your lordship take it up on Monday then.
Rest of the matters, your lordship may say Monday.
Let us see.
With due apology, my lord.
Yes.
May I draw your lordship's kind attention that I have a grievance. But this is not regarding the bench. This is regarding the registry against how my credibility has become zero. The open court order has been declared and registry, deputy registrar blocked that file, judicial order.
What?
That is in court number 25, I made a mention. And there is a special messenger notice issued on Wednesday, my lord. And when I want to deposit the special messenger cost, office told me no, DR said it will be listed before a division bench, and that is not informed me. And I have communicated to my client, and the authority also didn't get it. So when I inquire, that's my
Sir,
that is a propriety and recalling the order.
It's a High Court.
Yes.
The matter is listed in the High Court.
Yes.
So far as which bench it will be listed.
That's not there. Well, is the open court a special messenger notice already issued?
True.
Matter already heard.
So
That-
the bench which granted you a liberty, you can go and mention.
I did a mention, and the honorable judge told me that DR came and there was a small meeting, and DR said it is a division bench, and without my intimation to me. That is my problem, my lord, because I have.
Madam.
Yes, yes.
Sometimes it so happened that when you file a writ, then there may be some problems whether it will go to the single bench or a division bench.
Yes, yes.
Once it is found that it is a division bench matter, then the matter would be
Recall.
it would be listed
Yes.
to a division bench.
Yes, my lord, that is my case.
So
Single bench.
it is listed before the division.
No, single bench order not recalled, and
that order is a nullity if the single bench did not have the roster.
Yes, my lord.
And the matter does not pertain to single bench. Then, if any order is passed,
my lord, that's a nullity.
without jurisdiction.
Yes, yes. Lordship, I'm entirely agreeing with you. Madam, I'm entirely agreeing with you. But that should be intimation to the petitioner concerned. Otherwise,
I do not know nowadays because of the technology.
I may be a
But
fool,
in
my
those days when I started practicing,
Your lordship
those
was
days
better.
it was only a listed.
Yes.
So we used to get information after the matter is listed in the cause list.
Yes.
So has it been listed before the division bench? Your matter.
No, my lord, it is before single bench.
Has it been, if it is a matter of a division bench, has it been listed before the division bench?
No, that is my case, my
It
lord.
will be listed, it will be
Date
listed
is
before the
listed.
decision bench.
My lord, my case before you. I am making a case because now I am a crook. I fooled my client. My lord, what? I am a tout.
It so happens sometimes. It so happens sometimes.
My case is only judicial order passed in the open court. You can recall.
Then I'm giving you my experience.
Order dated 18/4/2024 under Annex 1, passed by this Honorable Court has not been
Yes.
complied with. The order under Annex 1 dated 18/4/2024
Yes.
has not been implemented.
My lord,
Is the first time it has come?
Yes,
Or the
first time. Yes, first time.
notice is
Yes.
given? Notice, return the affidavit, counter affidavit within 2 weeks. Rejoinder, if any, 1 week, matter to appear after 3 weeks. Just consult my brother and fix it. Any Friday.
Item 2. Minutes. In this case, minutes, order dated 20 minutes
My lord,
by the government minutes. Because we have already sold the land minutes under the Surface Act and we have already taken possession minutes, only minutes LDT has to be executed minutes.
my lord, I pray for 1 week time, my lord. Comply.
Or you are in contempt, sir.
Yes.
And you visualize. There is one judgment of the Supreme Court that if there is a delayed compliance, that is also a contemptuous act. Yes. A pre-judge bench decided over by then the Chief Justice of India, Justice Kapadi. If I am not wrong, 2012. It says that the dormant and lethargic attitude of the contemner in compliance of an order, though he complied later on, is also a contemptuous act. If a time limit is given, then you will have to either seek an extension of time to comply before the period expires, or you have to comply. How many times we will give you a respite to give 1 week time, sir? It's not so easy, sir. It's not so easy that you get away with this. Ms. Das, activate your process. 2 words in a contempt, dormant and lethargic. I think these 2 words were used in that judgment of Justice Kapadi. If I am not wrong, it must be 2012 judgment. Three judge bench decided over by Justice Kapadi. Maybe. What is this? Which year?
Decided on 13th October 2011.
2011
decided on.
But reported.
I'm just checking this.
If my memory does not betray me, must be in 2012, volume 2 SCC. Is a judgment worth reading when you are asking for a test? Yes. The matter appeared in the month of December 2024 with my brother. Asking a week's time.
Minutes.
Find out that judgment if you want to.
Minutes.
Yes, 1 week instruction. Yes.
Probably.
2012,
Item 3.
volume 14 ACC. 2012, volume 12 ACC. This is Justice Kapadia. Page 599.
No.
2000.
Yes. Look at that.
Minutes. Probably.
Yes.
Item 3.
Last occasion to direct to government file a affidavit, my lord. Order dated 31 July 2025, my lord. Direct to government file affidavit.
What? I could not get it.
My lord, last
occasion. On the last occasion, we prayed for some time to file an affidavit, my lord. Actually, my lord, affidavit is ready, my lord. We'll be filing by tomorrow, my lord.
Tomorrow? It's time to file affidavit is extended by 3 days from date. Rejoinder, if any, shall be filed within a week thereafter. This is the matter on.
list and matter. Any day.
Item 4.
Yes, ma'am. So this is the non-compliance of order dated 2nd July 2024. Under annexation case. The direction done to approve my tender, in view of the two judgments. That is page 12.
Page 12.
12 of page 12. Paragraph 2. It is agreed by the learned counsel of parties that the issue involving the writ petition has already been decided.
That is different.
Paragraph 4.
Yes, what has happened? Have you accepted the tender?
My lord, state has challenged this order for the Honorable Supreme Court.
What has happened?
The SLP is filed.
SLP will not do. What is the outcome of the SLP? Is it still at the diary numbers, or if the SLP has been given, it is listed, issue notice, what?
My lord, it is still in the diary number. Still in the diary number.
Along with section 5? Has to be along with section 5?
Yes. Yes.
What? We are filing.
These are not automatic.
Oh,
yes.
What to do?
For the first time, it is coming.
File your affidavit. Is that opportunity has to be given?
Yes, yes, Lord. In both the matters, item 4
2 weeks or what?
3 weeks.
3 weeks, 1 week, 4 weeks.
Yes, obliged.
The next matter is also sent.
Item 5.
Item 5.
Same, sir.
Okay.
Yes.
Item number 6.
Please, Your Lordship. My Lordship order, the 4/3/2024 are annexure 1, my Lord. Has not been 4/3/2024, my Lord.
Yes.
Has not been complied with, my Lord. The portion is page 19, Your Lordship. And all the petitioners, they are the displaced person, my Lord. As per the rehabilitation scheme, they have not provided the
representation considered.
For the first time, it is coming. Taking talks in this matter. And my lord, today I have got the instruction also, my lord. The director and the special secretary has requested.
Contempt. 6 weeks.
I have filed contempt 15/4/2024.
15/4/2024.
25. After receiving the statutory copy, my Lord, I have sent the order on, my Lord.
It's after 1 week.
I sent the order on 22/4/2024 to the opposite party, my Lord.
Contempt of person.
1 week.
Yes. File your affidavit.
Yes.
Item number 7.
Same, my Lord. Similar. Similar.
Same order. Date
Yes,
of the order.
yes, ma'am.
Here 156 petitioners there. They are all displaced. File your affidavit. 3 weeks, 1 week, 3 weeks.
Item number 8.
No affidavit filed by you. Oh,
Sir,
I 2 months time to comply with this order. The steps have already been taken.
so what? The order was passed when?
20
Yes,
9th April 2020.
I gave you a judgment, read it. Does not absolve you of the responsibility. File your, disclose your conduct in the affidavit, because that's a valuable right which is given. So 3 week, 1 week, 4 week.
Item 9.
This item.
What is the order?
Order dated same 9/4/2020.
9/4.
2024.
And when the writ is, the contempt is filed?
Contempt was received on 12th June 2025.
12th?
June 2020.
12th June. And the order was?
Order was
April?
Yes.
9/4.
9/4. What was the time for compliance?
Three months.
No. Please. File your order. Next.
Item 10.
Please, your lordships. It also, my lord, similar to, my lord, item 4 and 5. The order dated 2nd July 2024 not complied, my lord. The operative power to approve the tender within a stipulated period. 3 weeks.
3 weeks or 3
3
months?
3 weeks, your lords.
July 24.
Yes, lords.
When you have filed the contempt?
My lord, I filed on 19th June 2025.
19. File the affidavit.
That's here. Similar matters, my lord. SLP is directed to be filed against.
This contempt is all different. It all depends upon your conduct. You have to give.
After filing of the contempt, SLP is prepared.
And each of the contemners have to file a separate affidavit. Next.
Next is same, your lords. Same.
11.
11.
11 is same as item 10, similar to item 10.
Same day filed. June 5.
That's date 19.
19. Yes, it's 19.
Same day, lords.
Yes.
Item number 12.
May I please, your lordship? Lordship, on the last occasion, there was a prayer for dispensation of the certified copies that were to be filed by a direction of this honorable court dated 3rd May 2024. Your lordship, I have already filed the certified copies. Only annexure 6.
What do you expect? To give a compliment for that you have filed a certified copy. So we are accepting and glad that you have filed a certified copy. Let it be tagged with the record. The certificate when you file?
Your lordship, it was already filed on 9th May 2024.
Will be tagged with the record. Yes. Next.
Only last time, your lordship, there was a direction to file certified copies of 1, 2, 4, 6 and 8. 6 is not an order. That may be deleted, your lordship. It's a petition.
6.
Yes, your lordship.
The counsel appearing for the petitioner submits.
Lordship, I'm ready today. Your Lordship, the matter pertains to the addition of the share application money that was amounting to 72 lakhs from one Messrs. Heat Dealers Company Limited. That said transaction that that has been made was rejected and the money was added to my income.
By the income tax authority?
Yes, Your Lordship. By the order of assessment under section 143(3).
143.
Yes, Your Lordship.
Then
Doubting the genuineness, creditworthiness of the
that
said transaction. Yes, Your Lordship. So the limited point involved in this petition was whatever documents had been asked of me, I have already submitted before the said authority. Without taking into consideration, the order of assessment was passed. Thereafter, I filed an appeal. Appeal relegated me back again for reassessment, Your Lordship. Same thing persisted with the reassessment authority as well. Pointing those defects out, I filed a revision.
The observation of the appellate authority while remanding the matter to the assessing officer.
To take into consideration the said documents and verify the the creditworthiness and genuineness of the said transaction pertaining to 72 lakh some odd rupees.
It was a corporate the investments, or it was the application for shares to be allotted to you?
Shares to be allotted, Your Lordship.
Pursuant to any public notice issued by the company?
That,
So
Your
it's
Lordship.
a public limited or a private limited company?
This is a private limited.
Shares of
Private limited company.
Heat Dealer Private Limited.
Heat Dealers Private
So it
Limited.
is not has not gone into a public domain.
No, Your Lordship.
In lieu of investment in the company, you wanted a share.
Yes, Your Lordship.
Then
So again, Your Lordship, I filed a revision pointing out those defects, Your Lordship. That
no
this
assessing officer what it did after remand?
again, Your Lordship, that no opportunity, despite granting several opportunities, I did not appear. However, I have sent all the documents through registered post, Your Lordship. Due to this relates to the region in Sambalpur, Your Lordship. Persistently, there has been strikes that were going on due to the Western, the demand of the Sambalpur lawyers for setting up a high court in Sambalpur. So, due to that, Your Lordship, I could not be present personally, and the assessment order was passed ex parte, the set aside assessment order. Pursuant to that, I filed a revision under section 264. That said 264 revision was dealt in. I have filed the entire petition. I have furnished all the documents, Your Lordship. Subsequently, when I was present before the said officer, before the dealing officer, I was told that the PO is absent. However, on the very same date, the order of revision was passed saying that I was never present in the office. And I have filed my written note of submission along with a list of all the documents that needs to be furnished. The same has not been taken into consideration.
Have you stated that on oath in the instant review?
I have stated
you were personally present before the officer, and the officer was not physically present or on leave or whatever.
Yes, Your
you were
Lordship.
told, and thereafter you left without being heard.
Yes, Your Lordship.
And
Para
the
13.
order appears to have been
Para 13, Your Lordship.
Para 13.
My petition, Your Lordship.
Now, Mr. KD,
Your Lordship, in this case,
if that being the position,
no, Lordship,
it's a denial of an opportunity.
no, Lordship, in this case, they sought an adjournment on 5/3/2020.
We are concerned on the date of an order. We are not concerned the earlier what has been.
He didn't appear on that date, Your Lordship, on
Didn't appear.
5/3/2020.
Now, if he says that he appeared,
No, they didn't appear. That's why the order was passed on 21/4/2020 to under 13. 21/4/2020, we passed the order under section 264.
So that must be a date fixed by you.
On 5th March 2020, they sought an adjournment, and that day they didn't appear.
They
didn't appear.
They sought for an adjournment in the month of March.
My lords. No, date was fixed on March to appear on March.
Right? They sought for an adjournment.
My lords.
You fixed the date in the month of April.
No, March 3rd, 2020. The date was fixed.
Adjournment was denied.
No, we given an adjournment, and date was fixed on 5th March 2020, and they didn't appear.
What is the date of the order?
Date of the order is 21 April 2020.
So 21 April order, that was not a date when the matter was fixed.
No, after giving an opportunity, we pass our order accordingly, Your Lordship.
The order is passed subsequent to the date of hearing.
Hi, Your Lordship. On the opportunity was given on 5th March 2020. Then they didn't appear. After that, after 1 month, we have passed an order, Your Lordship.
The set date when the hearing was fixed, Your Lordship, I was present. I was told that the
On
PO is. Yes, Your Lordship. That is the averment at para 30.
Then
Like my
who is
learned.
to be believed, sir?
Because, Your Lordship, there is no mention of any adjournment being sought on 5th of March. I was very much present there, Your Lordship.
Who is to be believed then?
Your Lordship, let the matter may be fixed on another date. I'll be clarifying all the things.
You have to deal with this allegation, because if she is very categorical and says that her client has already affirmed an affidavit, on oath said that I was personally present, then
No, Lordship.
there is no denial on oath by you. Doctrine of non-traverse has to be applied then.
Your Lordship, on 14/2/2020, the AR appeared and sought for an adjournment.
Probably you could not get it.
Your Lordship.
The question is that on a day when he appeared,
5th March.
on a day when he appeared, whether the PO was there or not, because past incident may not be a factor. If he was reluctant, but the authority has granted time, that means that reluctance have been condoned by him, and he fixed another date.
Right.
So you can't take a past conduct in that sense. On a day when you passed an order, whether he was physically present,
No, that.
whether you were physically present.
Sure, Your Lordship.
Our allegation is that you were not physically present. Yes.
On the day which the order has been passed.
On the day when not.
When the
on
was
the
fixed.
day when you concluded the hearing. Yes. You have passed an order 1 month after the
Yes.
hearing is concluded.
No, no.
I mean, the hearing is closed. May I use the word? Hearing is closed, not concluded. On the day when you close the hearing, whether he was present or not.
That
He says that I was present.
But
you were not present.
But to my knowledge,
Give him an opportunity. You just go say it's a transaction, whether it's a clandestine transaction
it's a clandestine
or what, decide it.
Okay.
Genuinity of the.
Your Lordship.
Just yes, some in paragraph clear. Yes, how she is about paragraph.
Your Lordship, page number 20, we have clearly mentioned he requested for the time and the case was refixed on 5/3/2020.
Nowadays, I do not know. Nowadays means, sorry, I have come across with this kind of a verification, and the affidavits are very clumsy. I do not know whether it is a practice prevalent here. This can't be. You have to say if the statement made in every paragraph to be either true to your knowledge or derived from the record or derived from somebody else. What is kind of a affidavit?
In fact, nowadays, Your Lordship, from 2023 onwards, as Your Lordship is saying, those affidavits are being filed. That the fact stated at para 1 to such and such.
Is that true to my knowledge?
Yes, Your
Those
Lordship. Nowadays,
stated in these paragraphs are the information derived from the record,
yes, Your
which I
Lordship.
verily believe to be true.
Yes, nowadays
And
it is
then the rest are my submissions.
nowadays the same is being done, Your Lordship.
The petitioner has been subjected to different
Well,
We have been very moderate, very considerate, sympathetic. Withdraw. Yes, withdraw.
obliged to.